Hello, everyone. We'll start our program. It's 3:01 already. It is a Brazilian tradition to wait for a few minutes, but let's try to be as punctual as we can. My name is André Oliveira. I'm a partner here at Daniel Law, specialized in trademarks, and I'm very happy to welcome you to this webinar, The Future of Trademark, which is in fact the first event of a series of webinars we intend to have throughout this year. And we couldn't think of a better topic to start than reviewing case law on trademarks from last year, from 2024, because it was a very busy year for our courts and also for the PTO. So we'll cover a little bit of both. During this presentation, we will discuss decisions on topics such as 3D trademarks, genericness, bad faith, position marks, unfair competition. So there's a bit of everything to be covered. And as you know, Brazil is a civil law country, so we don't have binding precedents per se, but all these decisions were issued by specialized courts. So it is from our experience, we know that these understandings that we will discuss very shortly are very likely to be followed in the future. And this is why we are talking about past decisions, but we are also talking about the future of trademarks in Brazil. We will start with Lívia Elaiel. So Lívia will discuss Landmark, a leading case in Brazil about 3D trademarks. She will be followed by Rafael Rocha, who will cover two decisions, interesting decisions, cancellation decisions, which are based on bad faith, passing off, unfair competition. And even in one of those decisions, it was issued in favor of the plaintiff, although the statute of limitation for cancellation had already passed, which of course is not very common. After that, we'll have Fabio Leme talking about, again, a very relevant case we had last year covering genericness and cancellation of a registration for a generic expression, and which is a criteria for a mark to be considered generic or not, or for an expression to be considered generic or not. After that, Roberta Arantes will shift a little to the PTO side, and we'll discuss a couple of new regulations from the PTO covering issues such as secondary meaning, position marks. She will also talk about a court decision on position marks, which was the first decision issued in Brazil. And finally, we'll have Fernanda Vieira that, again, on more on the PTO side, will discuss recent resolution on slogans. So basically expanding trademark protection to moving from a stricter position from the PTO to become more flexible and accepting slogans as trademarks that can be registered in Brazil. So we have a lot ahead, and we want to thank you again and welcome you to this program. We will be monitoring our chat for questions and comments, and we'll be very happy and do our best to address them in the end of the presentations. So we're happy to start with Lívia. The floor is yours, Lívia. Thank you.
Hi, Andrea. Hello, everyone. I'm glad to see many friendly names here today. For those who don't know me, my name is Lívia Elaiel. I'm a trademark attorney and partner here at Daniel Law. Thank you all for joining. Today, I'm going to briefly discuss a very interesting decision that illustrates how court precedents have the potential of influencing broader trademark practices in Brazil. Over the years, the Brazilian Patent and Trademark Office has sometimes overlooked key concepts that could secure stronger rights for non-traditional mark owners. Until fairly recently, position marks, slogan marks, and acquired distinctiveness claims were not broadly recognized. This scenario has been changing, as it will be later discussed by my colleagues Roberta and Fernanda later on. Persistent efforts by rights holders who have repeatedly challenged the Brazilian PTO's rejections in courts and a more attentive approach from the new Brazilian PTO's administration have created a shift in how non-traditional marks are being treated. An excellent example of this effort is Sony Interactive's DualShock controller, which I will outline today. For context, three-dimensional registrations protect the unique shape or packaging of a trademark. In other jurisdictions, it would be something like a trade dress registrations, but the focus in Brazil is the shape, so we call them 3D or three-dimensional trademarks. The Brazilian PTO has traditionally taken a conservative stance on three-dimensional trademarks, often rejecting them or requiring exceptionally high thresholds of distinctiveness. The case I'm going to discuss underscores how courts recognizing certain unique elements in product designs can overturn the Brazilian PTO's initial refusal and pave the way for expanded rights in shape-based trademarks. Let's now explore how the DualShock dispute unfolded and why it has become such a game changer. Well, after Sony Interactive's application for the DualShock controller shape was refused by the Brazilian PTO due to lack of distinctiveness and functionality of the shape, the dispute then moved to the courts. In the first instance decision, the judge ultimately agreed with the Brazilian PTO's position, highlighting the following core findings. First, the court noted that while certain aspects of the DualShock layout and grip serve functional or ergonomic purpose, the functionality in question was not simply about the shape. In any case, a critical factor in the refusal was the recognition that a boomerang style of controller, uh, which is how they called it because it's characterized by curved grips and an overall arc shape, is commonly seen in the video game market. Because this general silhouette was already prevalent among competing devices, the shape itself was not deemed distinctive enough to serve as a brand identifier. Second, although Sony Interactive pointed to the specific arrangement of triggers, buttons, and analog sticks as distinctive features, the court concluded that these individual details were not pronounced enough to alter the fundamental boomerang design. As a result, these additional features did not transform the controller into a uniquely recognizable shape in the eyes of the court. Third, the judge remarked that a three-dimensional mark claiming protection for the exact product it represents faces an inherent difficulty. If the shape in question is the product itself, there is no pre-existing generic first meaning from which a second meaning could arise. Consequently, the second meaning claim was not available to salvage the mark either. Based on these findings, the first instance decision effectively upheld the Brazilian PTO's refusal. The court determined that the DualShock controller configuration, while widely recognized, did not display the type of inherent or sufficiently distinctive characteristics required to grant three-dimensional trademark protection. Despite this, next slide, please. Despite this setback, Sony Interactive appealed to the Federal Appeals Court in the second region in Rio de Janeiro. There, after extensive review, the appellate court reached a completely different conclusion. Unlike the first instance court, the Federal Appeal Courts concluded that DualShock was inherently distinctive. The arrangement and visual signature of the combination of elements played an important role in creating a distinctive overall shape. While acknowledging the widespread use of the so-called boomerang shape, the court determined that the DualShock's precise configuration combined with the distinctive elements of its features gave the controller a particular aesthetic identity not at all replicated by competitors. To the contrary, the DualShock overall configuration stand out from other controllers. Also, consumer awareness was a strategic factor. Although the court placed greater emphasis on the unique arrangement of the DualShock parts as a key factor in establishing trademark distinctiveness, broad consumer recognition bolstered Sony's position. The court explicitly mentioned that the market surveys demonstrate the vast majority of the consumers is indeed capable of recognizing DualShock controller, which confirms its distinctiveness. It is important to emphasize that the appellate court's decision was not based on secondary meaning or lengthy market use. Instead, the judges found that the design itself was inherently distinctive, even though it was inherently distinctive enough to function as a source identifier on its own. By overturning the Brazilian PTO's refusal, the court underscored that truly distinctive shapes can indeed function as valid trademarks if they go beyond purely functional or generic features. Plus, unique arrangement features play an important role in determining distinctiveness. This landmark ruling ultimately reversed the first instance decision affirming Sony Interactive's rights to register its iconic controller shape as a three-dimensional mark in Brazil. From a broader perspective, this outcome carries important implications. This decision clarifies that inherently distinctive product shapes can be registered as trademark in Brazil without having to rely solely on acquired distinctiveness arguments. The appellate ruling suggests a more flexible approach, indicating that even alleged commonly used shapes can achieve distinctiveness if other design elements are incorporated in a unique manner, standing out from competitors. In addition, substantiating the claim with a market survey can be strategic to evidence distinctiveness and market differentiation for competitors, bolstering the case as expressly mentioned by the courts. Next slide, please. In conclusion, the DualShock case exemplifies how steadfast advocacy can shift legal interpretations of non-traditional marks in Brazil. By weighing functionality, market prevalence, and the unique features of Sony Interactive's controller design, the appellate court broke with the first instance ruling, laying down a valuable precedent. As non-traditional trademarks continue to gain traction in our country, this decision will undoubtedly guide both brand owners and IP professionals in navigating Brazil's evolving landscape, trademark landscape. Thank you so much. Now I'll pass the floor to my colleague, Rafael.
Thank you, Olivia. Well, hello, everyone. I'm Rafael, and I have been handling trademark litigation cases and brand protection strategies at Daniel Law for the last 13 years. And my topic today is trademark registrations obtained in bad faith, which is a global problem, but treated differently in different jurisdictions, especially regarding the evidence that is necessary to prove bad faith. So today I will present two interesting precedents from the last year about registrations obtained at the Brazilian PTO in bad faith and how the Brazilian federal courts analyzed the matter. The first case is an invalidation action. Can you please move to the next slide, Bia? Thank you. This first case is an invalidation action filed by Advance Magazine, owner of the famous trademark Vogue, against a company named Marca Vogue regarding registrations obtained by the Brazilian company in classes 18 and 25. The particularity of this case is that the court action was filed after the end of the limitation period to challenge one of these registrations. As most of you know, in Brazil, the limitation period to challenge decisions from the Brazilian PTO in trademark cases expires in 5 years from the date of the decision. The exceptions are, of course, lack of use, which leads to the cancellation directly at the Brazilian PTO, and bad faith from the registrant, which is unanalyzed at the courts. But in this specific case, which was, of course, a case of bad faith, there wasn't any clear-cut evidence of bad faith, like a prior relationship between the companies or documents exchanged between them. But the only evidence was, in fact, a fact, which is the fact that the trademark was being used in handbags with a very similar logo, as you can see in the presentation. Even so, the courts ruled the case in favor of Advance Magazine, determining the cancellation of all registrations and the cease of use of the mark Vogue by the Brazilian company. The courts considered that the Brazilian company had prior knowledge of Vogue and intentionally registered the same mark to take advantage of its fame and influence in the fashion industry and consumers. Basically, the courts considered the Brazilian company as a free riding company. This decision was confirmed by the appellate court and also upheld by the Superior Court. Currently, it remains pending just an internal appeal, but with very remote chance of success. Well, this is not a leading case, but this is a very good example of how federal courts recognize or even presume bad faith based on context, fame, and circumstantial evidence. It's a little bit from other courts that request that has more higher standards for bad faith. But in Brazil, you can consider unfair competition, the fame, and a lot of different elements. It's very subjective, by the way, to be considered by the courts as a bad faith case. So this is one of the cases that was clearly qualified as a bad faith. Can you move to the next slide, Bia, please? The second case also involves bad faith, but with a different perspective. This is an invalidation action filed by New Balance, the shoe brand, against a Brazilian company named Club Happy, due to the registration of this logo, which resembles the letter H from Happy, from Club Happy, but also the letter N from New Balance. This application was granted without opposition, which is even understandable since it's a kind of generic logo. But we noted that it was being used in shoes that clearly copied the designs of New Balance shoes. Basically, we conducted surveys on the market and we proactively detected these products and linked it to these registrations, which of course, it's very strange. So this is not a case of an imitation or a misuse of a regular trademark, but it is a case in which the counterfeiter, because this is a counterfeit product, obtained a registration as a strategy to appear as a regular business and jeopardize enforcement actions. After all, especially in criminal actions, the enforcement is much more difficult if the infringer somehow holds any type of registration. However, once the case was submitted to the court, preliminary injunction relief was granted to immediately suspend the registration and determine the cease of use. On its response to the Brazilian PTO, on its response to the court, the Brazilian PTO changed its prior position and agreed with the cancellation of the registration. And in the end of last year, the trial court finally issued a decision on the merits, canceling the registration and confirming the determination for Club Happy to definitely refrain from using the trademark. This case shows how infringers can be creative and bold, since it was protected by a registration unduly obtained. Club Happy products were available in department stores and marketplaces where it's not common to find counterfeit products. So the customers were clearly confused by this company. However, there are some lessons from this case. The first is that the effective preliminary injunction system stopped the infringement in a matter of a very few weeks. Also, the straightforward procedure at the federal courts that fully prosecute the case at trial level in less than 2 years. And finally, a positive response from the Brazilian PTO that reviewed its prior position and agreed with the cancellation of its own administrative decision. So this was a case that was, well, the infringer obtained this strategy of obtaining the registration to make the enforcement more difficult, but it was solved very quickly at the courts. So it's also a good example for brand owners that face similar situation. So now my colleague Fabio will speak on a also very interesting case, I would say a sweet case involving evocative trademarks. So thank you.
Hello, everyone. Thank you for being here with us today. Well, Rafael mentioned a sweet case. Maybe it's not so sweet depending on the part in the case. But my name is Fabio, and I work with trademark litigation here at Daniel Law. So again, you are more than welcome here. Thank you very much for attending this online event. The case I would like to present you involves two of the biggest chocolate industries in Brazil. And they are known by their main trademarks, which are Copenhagen, which is the plaintiff in the case, and Cacau Show, the defendant. And they are known, it is very important that you know that they are both known by these main trademarks that I just mentioned. So this is the parties of the court action. And now let's go to the issue. The issue, as Andrea anticipated in his introduction, involves the registration of a descriptive trademark by the Brazilian PTO. Actually, the Brazilian PTO register what Cacau Show understand. It is an undue register of a descriptive trademark. And I'd like to also mention to you that both companies, both parties have lots of stores, no regions of Brazil. I can assure you that they have more than thousands of stores spread in Brazil. And let's go to the relevant facts of the case. First, a little bit historical of the case. Please, could you return to the last slide, please? Yes, thank you. A little bit historical of the case. So in 1987, Copenhagen obtained by the Brazilian PTO the register for this stylized trademark, this composite trademark, as you can see. But please note that the mark holds Copenhagen, the 5 stars, a figure of a cat, and the expression língua de gato, which in English means cat tongue. And this is the issue of the case and the issue of my presentation here today. Next slide, please. Great. So far, so good. All parties are moving well with their business. But in 2013, Copenhagen has applied at the Brazilian PTO for the língua de gato, cat tongue in English, as a word mark at the PTO. And for the surprise of some, the Brazilian PTO granted the registration of língua de gato. As you can see, língua de gato, cat tongue, represents the exact shape of the chocolate. But there are more. There is more. After the registration by the Brazilian PTO, the company had reinforced, Copenhagen had reinforced its enforcement program and start sending warning letters to the other players, including Cacau Show. At the time, Cacau Show intended to use língua de gato as a descriptive term in another product, not even related to the chocolate, but that's other thing. So when Cacau Show received the CD letter, the company decided to investigate a little bit more about língua de gato, about cat tongue. And we figured out that this expression was created in 1892, more than a century ago, in Vienna, but not as a trademark, but as the name of the chocolate, this form of the chocolate. It was created with exactly the descriptive function. But it doesn't stop here, because we verified that cat tongue or língua de gato or other translations of the expression is used in several countries, as you can see in the slide. So cat tongue, the meaning of cat tongue, which describes the exact form of the chocolate, the exact shape of the chocolate, is spread worldwide. Next slide, please. So, considering this descriptive use and coding, and considering their use not only in Brazil, but in a worldwide of the expression describing the form of the chocolate, the shape of the chocolate, Cacau Show decided, and I am quoting here my partner Robert Daniel, the best defense is a good offensive. The company decided to bring the case to the court, to the federal court, and then file a nullity court action in order to nullify the undue registration made by the Brazilian PTO for língua de gato as a word mark. And this case was very well disclosed last year. Actually, the decision by the federal trial judge was well disclosed by the Brazilian press last year. If you Google língua de gato now, we will see several notice regarding this specific subject matter. And the federal judge decided for the plaintiff. So the federal judge in Rio understood that, actually agreed with Cacau Show that this is the generic or descriptive term, and then decided for the nullification of língua de gato as a word mark in class 30 for chocolates. And I will present you now some of the legal grounds which based this decision. The first one is the own Brazilian trademark law, which established the prohibition, the forbidden of registered generic or descriptive signs as trademarks. The other main reasons that took for basis the trial judge is the quantity of players using língua de gato in Brazil at the time of the filing of the application for língua de gato as a word mark. At the time of the applications, the use of língua de gato describing the shape, the exact shape of the chocolate was spread, diluted in Brazil. The judge also took into consideration a market survey which obtained response for the Brazilian consumers, which see língua de gato as a type or a form or a shape of a chocolate, and not a trademark from Copenhagen. I believe this was one of the reasons, actually, that the judge took into consideration in order to step away the allegation of secondary meaning doctrine in Brazil. Copenhagen had alleged that this expression had acquired a secondary meaning, but the market survey showed the otherwise. The court also mentioned a prior case related to this program, this enforcement program from Copenhagen. In the past, the company filed a lawsuit, an infringement lawsuit against a supermarket net because the supermarket was using língua de gato, cat tongue, to describe the chocolate that it had been selling at the time. So But this was used by the trial judge more than a dicta, an author dicta, than the fundamental ground for the decision. Finally, and this is interesting because the judge also took in consideration that Copenhagen itself, in some opportunities, use língua de gato, cat tongue, not only as a trademark, but mainly to describe the shape of their products. So this is very interesting, in my opinion, and the judge took this in consideration in her decision. So the conclusion of the judge actually was to annul the trademark, the registration for the trademark língua de gato, cat tongue, as a word mark, and agreeing with all the plaintiffs' Cacau Show arguments in the lawsuit. Of course, and it is important, for the sake of transparency, it is important to say that this trial decision is still pending for appeals by the appellate court, by the federal appellate court in Brazil. But we believe that this is an interesting case, a very interesting case. And you may think that this topic, this subject matter is maybe yesterday news, but I can assure you all that it is not in Brazil. This case demonstrates an evolution, in our opinion. It is kind of relating to our title here, it's kind of a lesson from 2004. And I can assure you that the decisions involved this polemic subject matter is still foggy, especially at the Brazilian PTO, but also in the Brazilian federal courts. A few takeaways from us, from Daniel here, is please make sure that when you invest resources in a trademark, you do it in a mark that holds some distinctiveness, at least some distinctiveness. Do not invest or put effort in a trademark or in a generic descriptive expression. And the other one takeaway, the other one lesson is, once you receive, especially for the foreign colleagues here, when we receive a C and D letter, when you were summoned to respond to court action based on a trademark infringement, please check if this trademark was properly granted by the Brazilian PTO. If the examination fulfilled the conditions for a trademark, the distinctiveness. So I believe this is the two takeaways that I'd like to give you. I also would like to share with you that it is quite common in Brazil. We challenge the decisions from the Brazilian PTO. There is no, I believe there is not in the US actually, but in Brazil, I can assure you there is no Chevron doctrine here. It is quite common with the challenging, actually the parties, the companies, the persons challenges the decisions from the Brazilian PTO. Of course, we respect the trademark agents in Brazil, but it's quite common to challenge the decision. Actually, if you would like some statistics, our analysis here show that more than 50% of the case brought to the Brazilian federal court against the decisions of the Brazilian PTO are overturned by the courts. So this is a very significant number in our opinion. Thank you very much for having your time here again. I am totally disposal for questions. Actually, I would like to discuss a little more about the case with you. But now I would like to pass the word to my colleague Roberto Arantes, who will show you some kind of evolution from the Brazilian PTO about position marks. Thank you very much again.
Thank you, Fabio, for sharing with us your thoughts about this interesting case. It's still ongoing, so probably we'll have more issues to discuss about this case later on. But now, I'd like to initiate my presentation and share my thoughts with this esteemed audience on position marks, which will be my first topic. And of course, I would more than welcome questions. If you have those, you may send the questions either in English or Portuguese, and we'll be more than happy to answer all of them in the end of our presentation. So, first slide, please. As you know, and as some background information, in the Brazilian tradition, only marks that can be visually perceptible can be registered. No surprises here, that's what our law says. However, in 2021, the Brazilian Trademark Office introduced a regulation for the registration and protection of position marks. These marks, considered unconventional or non-traditional, follow a set of specific requirements that must be met for registration. So, by definition, a position mark results from the application of a sign in a given position on a support working as a source identifier, distinguishing it. Protection will be granted as a trademark, provided the design is applying to a single and specific position in our support. So it's an unusual position that would play trademark function. The support can be, for instance, a t-shirt, an oven, a TV set, and many other supports that could be a basis for a trademark registration. So one critical requirement is that this combination of a sign and its specific position must lack any functional purpose. In other words, a sign cannot be registered as a position mark if it's used to facilitate or enhance a product's performance. And we can move on to the next slide, please. If this sign aims to achieve a better aesthetic result, it cannot be granted as well. Even if the mark is intended to highlight parts of the product or indicate a specific usage, for instance, a safe usage, such as a push button, it cannot be registered. And for sure, if the sign serves as a mere ornamental or technical purpose unrelated to identifying the product source, it cannot be registered. So let's move on to the next one. When Ordinance 37 was enacted in 2021, applicants whose marks had characteristics suitable for position marks registration were given the opportunity to adapt their former applications. They had a window of 60 days to do that. And many applicants submitted petitions requesting that their marks be analyzed as position marks. In several cases, however, the Trademark Office issued office actions questioning whether the marks indeed qualified as position marks or should rather be prosecuted under their original classification as figurative or 3D marks. This was the case, and I brought two interesting cases to share with you. One of them was Havaiana's claim of protection for the brick pattern sole and Vans' claim for their sneaker design. Both cases ended up rejected by the Trademark Office as the examiners considered that the marks did not meet trademark function. As for the Havaiana's flip-flops, the examiner stated that the design of the bricks had the anti-slippery function and served the purpose to prevent accidents, lacking the required trademark function. On appeal, the applicant argued that the anti-slippery function is attributable mostly to the material used which is protected by patent rights, rather than the brick design itself. The appeal is still ongoing. As for the Vans sneakers, the examiner understood that the lateral drawings had mere ornamental function and was not distinguishable from other sneakers in the market. Both applicants have since then refined their claims and are pursuing protection under narrower scopes, which is one of the requirements for registration. These cases are both currently under appeal, so we have to see how the Trademark Office will react to the claims made in their appeal, or even if the parties will reach out to courts to have the cases reviewed. Interestingly, one case successfully advanced to registration, and I mean this sneakers from Auckland. They feature a three-circle design on the top and lateral stripes in the sole. This design was allowed into registration as a position mark. The crown design, which is also present in the sole and was initially claimed as part of the mark, has been withdrawn to allow the registration. In most cases, and I'm not being hyperbolic here, the Trademark Office denied protection for the position marks. And this raises very important questions. Is it fair to grant protection to some designs while rejecting other? What is the criteria used, which is still not clear to me? And what degree of distinctiveness should be required for protection as a position mark? This leads us to another discussion that turned out to become a landmark decision, and this one involves position marks and our second important topic, which is secondary meaning. This decision was rendered by the Brazilian courts. Most of you might have recognized the Louboutin soles here in these drawings and images. Since 2009, Louboutin tries to have their famous red sole protected in Brazil as a registered brand. However, it was not until 2021 that position marks became protectable in the country. So what many applicants did was file trying to protect the mark as figurative or rather 3D marks to secure some sort of protection, as Brazil is a first to file country, and use trademark rights does not derive from use. At least this is the main rule. Of course, there are exceptions to that. But anyways, a trademark registration is something really important for enforcement purposes. So in 2009, Christian Louboutin first sought to register its red sole as a trademark in Brazil. The prosecution of the case took many, many years, and to be more precise, it took 14 years, long years, while the landscape only shifted in 2021 with this Ordinance 37, which allowed position marks to be registered. Louboutin quickly updated its application, but the struggle didn't end here. In May 2023, the application was denied, which prompted the brand to take the matter to court. Despite its global recognition and favorable precedents, including in Brazil, where state courts already considered protection over the red sole in enforcement actions, the rejection was based on lack of distinctive character and the legal prohibition over a single color claim. The Trademark Office also reduced the scope of protection from shoes to high heel shoes, but this was not enough to grant protection. The turning point came when a federal judge recognized the distinctive nature of the red sole. The court acknowledged what we in the legal community refer to as secondary meaning, where consumers associate a specific feature, in this case, the red sole, exclusively with a brand rather than just a design choice. What was important and shift this decision, and I believe this was a key evidence of the case, a consumer study was provided, and this study involved Brazilian women across different regions and social classes in Brazil, and showed that over 60% of participants directly linked the red sole to Louboutin, even when compared with other luxury brands like Chanel, Gucci, and Prada. This evidence reinforced Louboutin's claim that the red sole had become a defining element of its identity. This decision, of course, has implications beyond protecting Louboutin's iconic design. It strengthens Brazil's IP framework, aligning it with the global standards and fostering a more competitive and fair market. For the fashion industry, this decision is key, because this industry in particular relies heavily on aesthetic elements to create identity and value. So I can say that this decision was actually groundbreaking and underscores the need to protect the unique identity of brands, ensuring that they can continue to innovate and thrive in a competitive environment. Besides, and this was one of the struggles the brand had, the trademark registration is a powerful tool to fight counterfeiters, and the decision represents a shift not only for the protection of a position mark, but also a landmark for the fashion industry as well. The aspect that I mentioned about the secondary meaning is also of key importance, because in Brazil, traditionally, the trademark office just completely disregard the secondary meaning claim. So in Brazil, by law, the registration of a single color as a mark is not allowed. However, the red sole case reinforces the identity created by a single color if used in a non-conventional fashion, and being a powerful source identifier. And let's move to the next one, please. Secondary meaning has been widely recognized by judicial decisions for long, but not until 2024. It remained as an alien to the Brazilian Trademark Office that simply ignored the argument in their decisions. Until then, decisions issued by the Trademark Office stated they were not entitled to analyze secondary meaning, or they simply didn't have jurisdiction on the matter because this is a factual matter and not a matter of law. So, and we can move on to the next one, please. In October last year, the office opened a public consultation on a draft ordinance regulating the recognition and protection of marks that acquired distinctiveness from use. And by the way, this public consultation is open until tomorrow. So if anyone intends to submit comments, this is the time, and rush, because the window of time is ending tomorrow. If they do not, postpone a little bit the public consultation. And despite a lot of criticism received by different players, the regulation of secondary meaning is for sure a great improvement in the Brazilian landscape. Under the proposed draft, applicants must raise the secondary meaning within their application or in appeal level, submitting evidence that the sign has been in effective and continuous use for 5 years and that it meets trademark function. And the key evidence provided should be market surveys. So market survey will play a critical role in supporting a secondary meaning claim. Recognize that consumers identify the brand as a source identifier, distinguishable from others in the market. And what the office wants is that the claimant proves that there was a shift in the meaning of the sign that makes it distinguishable and notable for consumers. So let's see how things will evolve from now. Following the consultation period, the Trademark Office will review the feedback and issue the final ordinance. So changes may come out of it. And we believe that we'll have further developments on the issue by the end of the year. So with this brief overview of position marks and secondary meaning, I will pass the floor to my partner, Fernanda, who will discuss the protection of taglines as trademarks. So Fernanda, please, the floor is yours.
Thank you very much, Roberta. Thank you for your comments on secondary meaning and position marks. So hi, everyone. My name is Fernanda. I'm a partner at Daniel Law's trademark practice. And now we're going to talk about the registration of slogans as trademarks. There has been some recent changes in the BPTO's guidelines. Those changes are very recent indeed. They are from November last year. And now the office has become more flexible into accepting slogans to be registered as trademarks. But before we dive into the impact of these new guidelines, let's first understand what was the prior scenario. So we do have a prohibition in our local IP law that bars from registrations signs and expressions that have that advertising, that promotional nature. This provision in the law was often used by the office to bar any trademark application that had this advertising nature that contained a slogan. Sometimes we are able to overcome this prohibition by sending evidence of use that the slogan was actually used as a trademark as well. Why is that? Because we focused on the legal text that says only as means of advertising. So if we are able to prove that the expression not only had a slogan nature, but could also function as a trademark, we were able to overcome these refusals. This posed some sort of a contradiction with our legal system because, as some of you may know, in Brazil, you don't have to evidence use in commerce to obtain trademark registration. But at the same time, the way that we found to overcome this refusal was by submitting proof of use. But now the new guidelines have come and the situation has become more aligned with this new view. So can we move to the next slide, please? Thank you. So first, it's important to say that the prohibition in our law still stands, especially because the office has no jurisdiction into deleting any kind of legal text from our IP law. But now the office will refuse if two conditions are met. And what are these conditions? The first one is that the office will verify if the mark has an advertising nature. What is an advertising nature in the view of the office? If it recommends goods or services, if it transmits the trademark holder's mission, values, ideas, or concepts, if it tries to persuade the consumer into buying that product or into contracting that service, or if even highlights a certain quality in a positive way of the goods and services in comparison to those of competitors. So this is the first condition, if the mark has an advertising nature. Second condition that the office will verify is if the mark itself, the slogan, lacks distinctiveness. What is the lack of distinctiveness in the view of the office? If these are expressions of common use in a certain industry, if they are merely descriptive or promotional, or if they are not original at all. So maybe this will become more clear with the examples. Here you have some phrases like safety first, taking care of you, guaranteed fun. As you can see, these are all slogans. They have an advertising nature because they are trying to transmit a certain idea. They try to highlight a certain quality of the goods and services. But at the same time, they are not really that original. These are phrases that you could see in different industries. They're already widely used. So both conditions are met, and then the office will apply the prohibition that we saw in the previous slide. So now if we move to the next slide, please. So now, how will the office apply, will not apply this prohibition? The office will see if the slogan can also function as a trademark. So if the slogan has this dual function. As you can see, this is already aligned with the type of defense we used to practice before the guidelines came into place. So now we can consider that the guidelines are some sort of formalization of a line of defense that we were already applying. So how will the office verify if it has this dual function? First possibility is the combination of a distinctive expression with those of advertising nature. So as you can see here in the example, Bretas, always the best service. Always the best service is the slogan. It has that promotional character. It wants to highlight a positive aspect of the service, but it's not really that original. It could virtually apply to any segment, any industry. So this phrase per se would apply the two conditions that I said, lack of distinctiveness and advertising nature would apply here, and the phrase always the best service would be refused as a trademark, as a registration, to proceed to registration. But because it is combined with Bretas, which is a distinctive word, a registered sign, the office understands that the mark in its entirety has the necessary degree of distinctiveness to proceed to registration. So this is the first situation in which the prohibition would not apply and the mark will be allowed to proceed to registration. If there is a slogan that lacks distinctiveness, but it is combined with another expression or expressions that do hold a degree of distinctiveness, of originality. Second situation is if the same phrase can work both as a trademark, so it can work as a source identifier. It has the distinctive function to distinguish goods and services, and at the same time has an advertising nature, can work as a slogan. So in the phrase, I can't believe it's yogurt, you can see that there is a promotional nature in the phrase because it's trying to highlight a certain quality of the product, but it's not really direct. It's not really being saying to the consumer directly to buy the product. It rather plays with the feeling of surprise of the consumer. And so it gives multiple interpretations. There is some nuances involved in this phrase. So in cases such as this, the office understands that the mark has a higher degree of distinctiveness, and then it can proceed, even though it is a slogan, because it has a higher degree of the originality, it can proceed to registration. One important comment is that now the examiner has the orientation of performing online searches to verify if the slogan has a distinctive nature, if it is of common use or not. This may be some sort of a surprise for some Brazilian practitioners because traditionally the examiner was very limited to that universe of the trademark office database, but now there is a guideline to go beyond and do and perform online searches to verify the degree of originality and distinctiveness of the sign. Next slide, please. And so what are the key benefits of this change? First of all, now Brazil is more aligned with the practices in other jurisdictions. So now you can structure a more global strategy for protecting your marketing assets, your IP assets, considering now that your slogans, which sometimes play a key part in branding strategies, can also be registered as trademarks in Brazil. And since some of my colleagues have already mentioned, Brazil is the first to file a country. So the rights arising from trademark registration can only be acquired after the registration is validly issued. So if I could pass along one main takeaway from my small lecture today is that the trademark office is becoming more flexible into allowing slogans to be registered as trademarks. And this opens a whole new set of possibilities of protection of your IP assets, and also enforcement measures are also more abundant for those who hold a registration for our slogan. So thank you very much for your time, for being here today. I'll pass the floor again to my colleague Andre for some final comments.
Thank you very much, Fernanda. Thank you for our partners, panelists. These have been very insightful discussions. Unfortunately, we ran out of time, so we would be happy to keep discussing. I had a question on my own, but we'll keep it for future events. And of course, anyone that joined us could make their questions, and we would be very happy to discuss further these decisions. I think the final takeaway is that the presentation shows that first, our court system is now very mature in the sense of being able to handle complex cases in terms of trademark issues, even in situations such as bad faith, even in situations where statute of limitation has passed. So even in these scenarios, we know that, and also because of specialization, that the courts are much more reliable and much more in favor of an efficient and effective protection of IP rights, especially on trademarks, which is the topic we're discussing here. And second, we see that the PTO is becoming much more open-minded in terms of acceptance of trademark registration, especially when it comes to non-traditional trademarks. So unfortunately, we're going to have to wrap this up because we are already 2 minutes after time. But I want to thank you so much for your time, for your participation, for our panelists, for our staff, and of course, more importantly, from all of you that could be here with us. So stay tuned for further events and further webinars from Daniel Law. Thank you very much. Have a good day.